In my last video, I took you on a tour within section 109 of the Australian Constitution. If you arrived in this video without watching that one first, stop, click on the top right corner, watch that video, and then come back to this one. Because there we have seen what section 109 of the Australian Constitution is all about. We looked at the three elements of section 109. We looked at what it means by the expression laws, by the expression inconsistency, and by the expression invalidity. In that video, I promised you that today we were going to look at some cases decided by the High Court of Australia about section 109 and what happens when there is an inconsistency between the laws of the state and the laws of the Commonwealth. So, if you have watched that previous video, here comes the introduction. Hello everyone! My name is Renato Costa, this is Aussie Law, and today we will look at some cases decided by the High Court about section 109 of the Australian Constitution. I've selected only 3 cases among the many cases decided by the High Court of Australia about section 109. Look, seriously, there's so many cases, so I can't go into all of them and I cannot go into detail in each one of the cases that I'm going to talk about. But I still hope that they will give you a sense of what happens in practice when there is an inconsistency and what an inconsistency between the laws of the state and of the Commonwealth really look like in practice. So let's start with the first case. It's called R and Licensing Court of Brisbane ex parte Daniel from 1920. In this case, we will look at a type of direct inconsistency called a conflict of duties. The Queensland government proclaimed the 5th of May 1917 as the day for the election of the Queensland senators for the federal parliament. On the same day, a poll was held about alcohol licensing under the Liquor Act of 1912 of Queensland. The voting on that poll favoured a reduction of the alcohol licensing. And with that, the Brisbane Licensing Court decided to cancel the alcohol trading license of the Regatta Hotel. The owner of the Regatta Hotel, Daniel, he challenged the decision of the Brisbane Licensing Court, and the case ultimately went to the High Court of Australia. The argument of Daniel was that there was an inconsistency between the poll held under the Liquor Act of Queensland and another act, section 14 of the Commonwealth Electoral Wartime Act of 1917. Section 14 of that Commonwealth Act said the following: on the day appointed as polling day for an election of the Senate, no referendum or vote of the electors of any state or part of a state shall be taken under the law of the state. So the High Court had to answer if the Liquor Act from Queensland was inconsistent or not with that Electoral Act of the Commonwealth. In the opinion of Chief Justice Knox and Justices Isaacs, Gavin Duffy, Rich, Stark and Powers, there was an inconsistency between the state law that commanded the voting to happen in that day and the Commonwealth law that forbade voting from happening that day. Justice Higgins also understood that there was an inconsistency in this case, and in this sense he also followed the majority in this matter. However, in his own separate opinion, he said that he couldn't see any direct inconsistency between the text of the two laws. The problem for him was not the text of the laws itself, but the choice that was made under the Act to have the polling on that day. Basically, what his Honour said was that the choice made under the Act was invalid, and therefore the effects of that choice were also invalid. There was still an inconsistency. And, as you know, according to section 109 of the Australian Constitution, if there is an inconsistency between a state law and a Commonwealth law, the Commonwealth law will prevail and the state law will be invalid to the extent of that inconsistency. So, for the happiness of Daniel and of everyone that went to the Regatta Hotel at that time, the local poll on liquor trading licenses was deemed invalid by the High Court of Australia. Another case that deserves our attention is called Clyde Engineering in Calburn. That case is from 1926. In Calburn, we see a different kind of inconsistency of laws. This is a type of inconsistency that is usually referred to as a modification of rights. This happens when a law of one of the spheres, the Commonwealth or the state, modifies or destroys rights, powers or privileges that were given by the other sphere's law. Let's go to the facts of this case, because I think this will become clearer. So, Calburn was employed by Clyde Engineering. There was a Commonwealth arbitration award that fixed the rate of pay and overtime on the basis of a 48-hour working week. But there was also a New South Wales Act that dealt with the same matter, that fixed the prices for a 44-hour working week. And do you remember that an industrial award can actually be considered law under Section 109 of the Australian Constitution? So which one should prevail? Calburn said that he should receive the rates according to the 48-hour working week, the Commonwealth Industrial Award, although he was only working 44 hours a week under the legislation of New South Wales. So, the industrial relations between Calburn and Clyde Engineering, were they regulated by the Commonwealth Award or by the New South Wales Act? That was the question before the High Court of Australia. Although it was argued that there was no inconsistency because it was possible for the employer to pay, according to the award, a 44-hour working week under the state law, the High Court actually found that the state law was invalid. There was an inconsistency between the Commonwealth Award and the state law. According to the decision, the state law operated to modify a right that was given by the Commonwealth Arbitration Award. So, even though here the employer could still potentially obey both laws, there was still a modification of right. The state law was still modifying the right that was given by a Commonwealth law. Let's take a look at what Chief Justice Knox and Justice Gavin Duffy said. Two enactments may be inconsistent, although obedience to each of them may be possible without disobeying the other. Statutes may do more than impose duties. They may, for instance, confer rights, and one statute is inconsistent with another when it takes away a right conferred by that other, even though the right be one which might be waived or abandoned without disobeying the statute that conferred it. If there is a conflict between two laws, and even if it is possible to obey both laws, the federal law will prevail over that part, that section, that provision of the state law that is inconsistent to it. That means that to the extent of that inconsistency, the state law, that provision of the State Act, will be invalid. So these were two cases that I think can help us understand a bit more about what is a direct inconsistency. We saw one case about a conflict of duties and one case about a modification of rights. If you still want more examples, go back to my previous video, the one that I did only explaining the provisions of Section 109, because there I gave two fictitious examples of these two kinds of direct inconsistency. And if you don't want to miss any of our videos, don't forget to subscribe to our channel, hit the bell icon, because then you'll be notified every time I upload new content to this channel. Okay, can you handle more cases? Because I still need to talk to you about one more kind of inconsistency. It's a different approach. It's referred to as covering of the same field type of inconsistency. Let me just tell you that in the case that we just looked at, in Calburn, Justice Isaacs identified the source and gave an explanation of what covering the same field means. For him, the Commonwealth Award covered the whole field regarding the payment rates of the work that Calburn did for Clyde Engineering. And so in Calburn, look at what he said. Was the second act on its true construction intended to cover the whole ground and therefore to supersede the first? If it was so intended, then the inconsistency would consist in giving any operative effect at all to the first act, because the second was intended entirely to exclude it. If, however, a competent legislature expressly or impliedly evinces its intention to cover the whole field, that is a conclusive test of inconsistency where another legislature assumes to enter to any extent upon the same field. I cited part of this opinion in my previous video as well, because this summarizes the whole of the idea of the inconsistency via covering the same field. So let's take a look at a new case now. This case is called Ex parte McLean from 1930. In this case, there was an imposition of certain penalties if an employee didn't comply with certain terms and conditions arising from their contract. And the penalties were applied by the New South Wales Act and also by an industrial award. Again, an industrial award with the force of law. The problem was that the state law and the Commonwealth award, they fixed different sanctions in case an employee did not fulfill its obligations. McLean worked for Fifth, a grazier from New South Wales, and Fifth accused McLean of underperforming and failing to fulfill his contract. When McLean was convicted by the New South Wales Court of Petty Sessions, he argued that the New South Wales Act was inconsistent with an award of the Commonwealth. So the question went again to the High Court, and once more the High Court had to decide if there was an inconsistency between the New South Wales Act and an award made by the Commonwealth. And they decided that there was an inconsistency, and that inconsistency was of the type mentioned by Justice Isaacs in Calburn, a type of the covering of the same field. Justice Dixon adopted Justice Isaacs' test in Calburn and said the following: when the Parliament of the Commonwealth and the Parliament of a state each legislate upon the same subject and prescribe what the rule of conduct shall be, they make laws which are inconsistent. The reason is that, by prescribing the rule to be observed, the federal statute shows an intention to cover the subject matter and provide what the law upon it shall be. If it appeared that the federal law was intended to be supplementary to or cumulative upon the state law, then no inconsistency would be exhibited in imposing the same duties or inflicting different penalties. The inconsistency does not lie in the mere coexistence of two laws which are susceptible of simultaneous obedience. It depends upon the intention of the paramount legislature to express by its enactment completely, exhaustively, or exclusively what shall be the law governing the particular conduct or matter to which its attention is directed. So, in applying this test to the case at hand, Justice Dixon found that there was an inconsistency between the Commonwealth Award and the New South Wales Act. And that happened because both of them tried to cover the same field. They were working on the same matter. So pay attention on this, because if there is a Commonwealth law that has the intention of covering the whole field of the matter, what it means is that if a state law is enacted on that same matter, on that same field, that state law will be invalid under Section 109 because of an inconsistency of the type of covering of the whole field. By the way, if you want more videos about Australian case law, tell me by liking this video and also by commenting below. And if you want to watch the other videos that are already made about case law in Australia, check out the playlist that is appearing on the top right corner. As I said before, there are plenty more cases about Section 109 that were decided by the High Court of Australia. I can't look at them all, but I do hope that the three that we looked today, the three cases that I've mentioned in this video, helped you and gave you the necessary tools to understand not only the provision of Section 109, but maybe how to identify if there is a law, a state law and a Commonwealth law, they are inconsistent, or you also learned a bit more about the types of inconsistency of laws. This was the second video about Section 109 of the Australian Constitution. Leave a like if you liked this video. I hope you did. Thanks so much for watching, and I hope to see you again soon. Until then, ciao.